First of all, we're in the Northern District of California. LA's in a completely different federal district. The capital of California, where Gavin Newsom purportedly would have his office, is in a different district, federal district of California. But for some reason, Gavin Newsom ran to San Francisco, where I would note he used to be mayor. Before he was governor of California, he was mayor of San Francisco. And in that position, he was sleeping with his head campaign advisor's wife while he was married to a Fox News host. And we got a second $10 super chat. We're what, 10% of the way there. MP Schaefer says, remember, no kings, judges, and judiciary. So for some reason, we're in California. Anyone doubt why we're in the Northern District of California? Anybody doubt why? It is, of course, judge shopping. And what Newsom is shopping for is a temporary restraining order. Now, I'm going to come back to this because this is important for our understanding. Technically speaking, a temporary restraining order is not appealable to a higher court. And so it has become a common feature of these lawfare cases against Trump that these lower federal courts issue a temporary restraining order for 2 weeks, and then they're allowed to extend it another 2 weeks, none of which is supposed to be appealable by Trump. So he's frozen in amber for a full month. For a full month, the Article 2 executive branch of our government cannot function at the whim of any one of 733 unelected black-robed tyrannical inferior federal district court judges. Does anybody imagine that's the constitutional order our founders intended for our nation? That we were to be ruled by any one of 733 unelected black-robed tyrannical inferior federal district court judges? Now, eventually, a temporary restraining order might transition into a more durable preliminary injunction. A preliminary injunction, in theory, lasts for the length of the litigation on the merits, which could be months or even years in federal court. Either form of injunction, a TRO or a preliminary injunction, is by definition an extraordinary remedy that does not normally happen unless the defendant is Trump. Then these federal courts issue TROs and preliminary injunctions like it's raining singles at a strip club in Dallas. Also, the purpose of a TRO or a preliminary injunction is supposed to be to freeze the status quo, freeze things as they are. The analogy would be you wake up one morning, you have a maple tree in your front yard, and suddenly you see a bunch of guys with chainsaws about to cut it down. You don't know anything about this. You're like, stop. They're like, no, we have a work order to cut down their tree. You run to court. You get a temporary restraining order to freeze the status quo, to prevent the tree that exists from being cut down. Freezing the status quo. As we'll see, what this judge is being asked to do is nothing of the sort. The status quo, when this case arrives in Judge Breyer's court, is that Trump has federalized the California National Guard and deployed them to riot-torn Los Angeles. That's the status quo. What Newsom is asking for is not to freeze the status quo. He's asking for a change to the status quo. That's not the purpose of a TRO or a preliminary injunction, to change what's already existing, what's currently existing. Newsom is asking this judge to strip the commander-in-chief of the United States of authority over the federalized National Guard and hand it over to Gavin Newsom. That's not freezing the status quo. That's changing what's happening. So from the very beginning, this entire argument before this court is intellectually dishonest. Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney.
Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive, adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you.
By the way, I should mention, we do have... Let's see. We do have memberships active on the YouTube channel. And a ton of you have become members. Hey, Jules, great to see you. Such a reliable audience member and supporter of this channel. A bunch of you become members. It's only $5 a month to become a Patriot member of the Attorney Andrew Branca Show. And one of the benefits you get, even as a Patriot member, is these kinds of call-outs. So we have various levels of membership. If you're interested in supporting this channel, that's another way to do that. Tree Godfather says, based AF. Based AF. I almost went with that for our tagline, but I was a little worried about YouTube and also Facebook. So, yeah, Mike Moran, doesn't the word national denote who should command them? It kind of does, doesn't it? By the way, if I see people who are members, I'll call them out in the chat as time allows. But if you want to be guaranteed that a comment or question you have gets addressed by me during the live stream, it does need to be a minimum $5 super chat. All of those, I promise to respond to directly during the live stream. All right, so from the very beginning, this whole process is intellectually dishonest. We're in the wrong district, federal district. They're asking for a TRO not to maintain the status quo, but to change what is going on, to change the status quo. So let's get to some of these arguments. First of all, the Trump White House, one of the arguments of the Trump White House is, hey, you, Judge Breyer, unelected black robe, tyrannical, inferior federal district trial court judge, you don't even have the authority to second guess the president on military matters. This is non-judiciable. This is beyond the scope of the Article 3 inferior district trial court judges. Some things are, and these judges cannot bear the thought that there is anything outside their authority, that there is any limit to their jurisdiction, personal jurisdiction, subject matter jurisdiction. All these cases you're saying about immigration matters in federal district trial courts, the district trial courts have no immigration jurisdiction. That's been stripped from them by Congress. All these firing cases that you see in the federal district trial courts, the district courts have no jurisdiction over federal employment disputes. Congress stripped them of that jurisdiction and placed it in a separate administrative process. All these payment cases that you see where Trump is cutting off USAID money laundering funds, ending up in the federal district trial courts. They have no jurisdiction over federal contract disputes. The Court of Federal Claims is where Congress has placed that jurisdiction. But these unelected black robe, tyrannical, inferior district trial court judges cannot bear the thought that they are not in charge of all the things, not just in terms of subject matter. In terms of personnel, they issue these nationwide jurisdictions over people who are not parties to the case. They've never appeared before that judge, and the judge asserts jurisdiction over them. There's no geographic limits. These judges will issue orders to aircraft in international airspace carrying terrorists out of our nation and order those planes turned around and the terrorists returned. The arrogance, the tyranny of these judges, it's staggering. And the White House is pointing out here, this court of Judge Breyer can't even properly evaluate this matter because the relevant statute, 12406, reserves the determination of federalizing the Guard under these circumstances to the president's discretion alone. And this presents a preliminary question for the court to resolve before they can get into the merits. Now, let's take a look at that statute, because it's the statute that was cited by Trump when he federalized these National Guard. In his proclamation of June 7th, after the riot, looting, and arson had begun in LA, Governor Gavin Newsom and Mayor Karen Bass of Los Angeles would have you believe that everything was copacetic until Trump activated the National Guard. That's what catalyzed the riot, looting, and arson. It's a patent lie. The riot, looting, and arson happened because ICE was enforcing national immigration law in LA. That's what triggered the riots, looting, and arson. Somebody saw a bunch of ICE outside a Home Depot, thought they were raiding the Home Depot, and the riots started. It wasn't until the next day that Trump even began talking about the National Guard. The riot started on Friday the 6th. His proclamation did not happen until late in the day on Saturday, June 7th, and the actual arrival of the National Guard took place after that. But in his activation of the National Guard on June 7th, Trump cited a particular statute, 10 U.S.C. 1246. So let's take a look at that. Here it is, 12 U.S.C. 1046. Whenever, and these are three alternatives. You see the or here? Or. Whenever one of these three conditions is met, the president may call into federal service members and units of the National Guard of any state. And what are those three conditions? The first doesn't matter because the president didn't cite it, but it's invasion, foreign invasion by a foreign nation. The president did cite condition number 2, that there is a state of rebellion happening in Los Angeles against the authority of the government of the United States. And he also cited the third condition, that the president is unable with the regular forces to execute the laws of the United States. The question we're about to address in this opinion, the initial preliminary question is, who decides if these conditions have been met? Is this solely at the discretion of the president and he makes that decision and then that triggers his authority to do the rest of this? Or does an unelected black-robed tyrannical federal district trial court judge get to make this decision? Does the judge decide whether the National Guard, can be activated by our Article 2 executive branch president, commander-in-chief? That's the question. The first question we have to deal with. Because if this is solely at the discretion of the president, then the courts have nothing to say about it. The president simply announces that he's found this to exist, and therefore he has the authority to activate the National Guard. What Judge Breyer wants you to believe is that he gets to decide. He and any one of the other 733 judges gets to decide. And then when he gets to decide, after he's decided, it's up to Judge Breyer to decide whether or not these conditions have been met. Then he makes that decision in the most stilted, intellectually dishonest way I've ever seen in a federal district court temporary restraining order. So 2 issues, right? 1, who decides these questions? And then Do these criteria, do these conditions, have they been met by the facts on the ground? Judge Breyer, spoiler, a federal judge decides whether these conditions have been met. I get to make that decision. And then when I make that decision, I find they have not been met. And I strip the Article 2 executive branch president of his commander-in-chief authority over the activated National Guard, and I hand it to Gavin Newsom. Gavin Newsom. The order's dishonest in other ways, too. I'll get to those in a bit. So the White House position is the president is the only person who can make these calls. The president decides. It's in his discretion. And once he's made that decision, then he can call into service the National Guard. That's it. Now, another issue we'll get to in a moment, is that the statute also says the orders for this purpose shall be issued through the governor. Through the governor. Gavin Newsom argues, and Judge Breyer buys this, that order issued through the governor means the governor has a veto power over the president's decision. By the way, the whole reason 12406, this statute exists, is because in the past, we've had circumstances, generally during desegregation, where we had southern states that refused to activate the National Guard in order to enforce federal law on desegregation. They wanted to maintain their separate but equal schools by race, despite federal law. And the president wanted to activate the National Guard, and the governor said, no, I like being racist. So I'm not going to allow the National Guard to be activated. So Congress created this provision specifically to allow the president to activate the National Guard without requiring a governor request or approval. There are other ways a president could activate the National Guard that do require, they say in them, if the governor requests, subject to the approval of the governor. This statute does not say that. All the statute says is that the order shall be issued through the governor, not by the governor. The governor here is just a communication channel. It's a procedural issue. So we have a smooth transfer of command authority. Anyone who served in the military knows that you have a chain of command. If there's confusion about the chain of command, nobody knows who to take orders from. So the reason for this process, the order issued through the governor, is to have a smooth transition of command where everybody knows who's in command at any one time. It's either the governor through the adjutant general of the state of California, or it's the president and the federal command structure. We don't want any confusion about that. So we issue the order through the governor. By default, until the California National Guard is federalized by order of the president, it's responding to the governor as commander-in-chief. So if we're going to change that, we want that to be transparent to everybody involved. So we issue the change in command authority through the governor. That does not give the governor a veto or a right to consultation, which is what the governor is claiming here. Governor Newsom is claiming the entire activation of the California National Guard by Trump is ultra vires, outside the law, because Trump sent the order for activation to the California National Guard Adjutant General, the military commander of the National Guard in California under non-federalized circumstances, rather than giving it directly to the governor. It's an intellectually dishonest position. All right, but back to this first question here. The first question on, can this court even hear this issue? Does this fall within the jurisdiction of this court? The first question every court must ask itself, do I even have the legal authority to hear this dispute before me? And let's look at how dishonest this Judge Breyer really is. Justiciability. Can the court even hear this? Or is it solely within the discretion of the president? By the way, even if it's solely in the discretion of the president, that doesn't mean there's no check and balance here. It just means that the appropriate check and balance on the president is not the courts. It's the Article 1 legislative branch, which always has the power of impeachment over the president. And it's the check and balance of the American people, who always have the option of electing someone else president at the next presidential election. So normally federal courts, of course, can hear factual disputes. The Supreme Court has recognized limited exceptions to this general rule, one of which is known as the political question doctrine. Remember, Article 3 judicial branch is supposed to be apolitical, non-political, not making political decisions, making legal decisions. The political branches are the Article 1 legislative branch and the Article 2 executive branch. So if something's a political question, it does not fall within the scope of authority of the Article 3 judicial branch. This political question doctrine recognizes that certain questions, in their nature political, or which are by constitution and laws submitted to the executive, can never be made by the court. And that dates all the way back to Marbury v. Madison, the seminal Supreme Court decision in which they assumed for themselves the authority to decide whether or not laws are constitutional and what laws mean. And the seminal case on this, the canonical case from the Supreme Court on this political question doctrine, is something that Judge Breyer is going to talk about here. Baker v. Carr. Not that old a case. 1962. In Baker, the Supreme Court proposed 6 ways in which a case might present a political question and thus be unfit for judicial review. So it's not that rare. There's 6 different ways, according to the judicial branch itself, that they do not have oversight over a question presented to them if it's a political doctrine question. The relevant one for our purposes is the third of these. If it would be impossible to decide the issue without an initial policy determination of a kind clearly for non-judicial discretion. The courts are not supposed to make policy decisions. Policy is inherently a political process, and the courts are supposed to be apolitical. The White House contends that the third Baker formulation, remember, Baker is a U.S. Supreme Court case, this guy's ultimate boss within the Article 3 judicial branch. The White House contends the third Baker formulation, the existence of a policy question clearly for non-judicial discretion, applies here to render non-judiciable the question whether 12406 conditions for federalization of the National Guard were met. Remember, Trump says, the Article 2 executive branch, is the person who decides whether or not these conditions have been met, and I don't get second-guessed by the Article 3 judicial branch. The White House relies on the language of 12406 itself, stating that the White House states that the statute gives sole and exclusive discretion to the president to determine whether there is a rebellion or danger of rebellion. Remember, that's condition 2 of 12406 against the authority of the United States, which was cited by Trump as authority to federalize the California National Guard, or whether he is unable with the regular forces to execute the laws of the United States. That's the alternative third condition of 12406 that authorizes the president to federalize the California National Guard here. At the hearing before Judge Breyer, the White House contended the president could invoke 12406 on no evidence whatsoever and remain immune from judicial review. Yes, if the courts do not have authority over this question, they don't have authority over the question. They don't even get to look at the president's basis for the decision. Just like all of you in this audience, as much as I love you, you have no authority to tell me where I send my kids to school. And if you were to say, but Andrew's making that decision on no evidence whatsoever, that still does not give you authority to tell me where to send my kids to school. You simply lack the authority. And if you lack the authority, whatever evidence I may or may not have considered is irrelevant to you. That's the case here. And this judge says, and to be sure, when the executive possesses a constitutional or legal discretion, their acts are only politically examinable. In other words, checkable by Article 1, legislative branch, a political branch, and by the body politic, the American voter. Then the judge says, however, Trump misconstrues the plain language of 12406. But does he? the statute permits the president to federalize the National Guard whenever one of three conditions are met, not whenever he determines that one of them is met. This is this judge fecklessly misguiding the question. The question is, who decides if it's met? Who decides, the judge or the president? Yes, the statute says whenever one of these enumerated conditions are met. But who decides? What in this judge is saying, the statute doesn't say the president gets to make the decision. The president is mentioned. Are judges mentioned in the statute? If this judge's complaint is that the statute doesn't explicitly say the president gets to decide, where does it say a judge gets to decide? It doesn't mention judges at all. It's completely sidestepping the actual question here. If this were a law school student answer to an exam, I would fail him. Fail him. The White House points to the language providing that the president may call into federal service members of the National Guard. See this word? See this word? President. President. Where does it say judge? It doesn't, of course. As he considers necessary to repel invasion, suppress rebellion, or execute the laws, right? Those are the conditions Trump says have been satisfied. And this judge says, but your argument puts the cart before the horse. For the president to exercise his discretion, there must first be an invasion, rebellion, or inability to execute the laws. Yes, under 12406, those are the conditions for activating the National Guard under that statute. That's not the question. The question is, who gets to decide? Who gets to decide? The White House asserts that despite the plain language of the statute, but the plain language of the statute does not say what this judge is claiming. Despite the plain language of the statute, what does the statute say? Does the statute says the judge gets to decide whether those conditions have been met? No, it does not. Despite the plain language. So intellectually dishonest. This court says, Judge Breyer, the White House asserts, despite the plain language of the statute, the Supreme Court, 1827 Martin v. Mott decision compels a different outcome. I just want to point out here, the next few sentences I'll be reading are U.S. Supreme Court precedential decision. The ultimate boss of this guy. He doesn't like what the Supreme Court has to say here. So guess who he brings in as the counterweight to the U.S. Supreme Court? He brings in a ruling, but this year, 2025, by an unelected, black-robed, tyrannical, inferior district trial court judge, one of his peers, a mere trial court judge, and he gives that trial court judge's order, a lawfare order, one of these many lawfare cases against Trump, he gives that trial court judge's order more authority, more legal weight than he gives to the U.S. Supreme Court here. Man, I didn't expect to get this excited today. Folks, I love the law, and I love the process of the law, and when I see it corrupted, it makes me super unhappy.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.